Hello everyone, this is Roshni a legal intern with LEXIS and Company. In this video, I'll be explaining about the sedition law that is given under 124 of the Indian Penal Code. So basically, we have all seen that people being booked under sedition law for criticizing the government, for even making a statement against the government or any law is nowadays considered to be a seditious statement. So right now sedition is a very important topic that has to be discussed. So section 124 A of the Indian Penal Code is the most powerful tool, that is most powerful tool of the government against the citizen of the country. If you make any statement that is against the government, they have the power under the section 124A in order to punish you, even though that was not the intention behind creating that particular law. So basically, defection is not, or sedition is not something that can be just used like that. So in order to create affection on a particular government, it's not a very easy thing. We all know that certain communities may support certain government and certain people may support a certain government, and when you criticize the government, they could use a term of sedition, or they could punish you under seditious law for making statements that are contradicting to their the government's opinions. So basically, according to Mahatma Gandhi, affection is not something that can be created or governed by legislation. If you don't like someone or a system, you should be allowed to voice your displeasure for the maximum extent possible, as long as you don't plan, advocate or instigate violence. So this makes utmost sense now. Unless you create any violence, unless you instigate any particular a commotion in the society, your statements are not supposed to be considered to be seditious, but only the statements that are made out of your right to speak. So the current Chief Justice of India, N.V. Ramana, has highly criticized this particular law on 12th January 20, on 12th Jan after his swearing in. He has said that he has expressed his views that this is the most abused and the misused law in the Indian legislation. So sedition law is highly criticized by the Chief Justice of India, and he also states that many countries, including Britain, which enacted this particular law into India, have removed this law from their legislations. So you can see how harmful this laws can be, and it is also to be noted that in 1988 South Korea repealed this particular legislation too. So even in Australia, the term sedition is being replaced with the term urging violence crimes. So we could see that certain countries, major developing and developed countries, have been making changes to their legislation in order to make sure that people don't use the loopholes, or the government doesn't use the loopholes in the laws in order to hurt the citizen of their country. So even there was a suit filed by advocate Prashant Bhushan on behalf of the former IT minister Arun Shourie and an NGO for challenging the constitutional validity of section 124 and claimed that it is violative of article 14, article 19 clause 1 subclause A, and article 21 of the Indian constitution, despite the fact that the clause was affirmed by the Supreme Court in the Kedarnath versus state of Bihar in 1962, and the court held that this particular law is constitutionally valid. Certain appeals are still pending in front of the pending in the Supreme Court with regards to this section alone, in order to make sure this particular section is repealed. There are so many communities of people who want that this particular section has to be repealed. So This is one thing about the sedition law. So right now I'll be dealing with a case law, the first ever case law from India with regards to sedition, that is Queen Empress versus Jogendra Chandra Bose. So it is also famously called as Bungo Bussy case. So what happens is that the editor and the publisher and the manager and the printer of this particular Bungo Bussy newspaper are filed under the sedition law, that is 124A of Indian Penal Code, for violating or making seditious statements against the government. So it was claimed that these people have made seditious statements against the government. So now the matter is in front of the Calcutta High Court, and the Calcutta High Court clearly defined what sedition is. So basically the Calcutta High Court held that sedition is an emotion that is opposed to attachment. In other words, hate or hatred. Okay, so sedition is hate or hatred. Simple enough, disapprobation is disapproval. If a person uses either spoken or written words calculated to create in the minds of people to whom they are addressed a disposition not to obey the lawful authority of the government or to subvert or resist the authority if the occasion arises, and if he does so with an intention for creating such disposition among the hearers or the readers, they will be guilty under this section. Unless and until you create violence, unless and until you instigate commotion in the society, unless and until you are going to put in wrong intentions into the head of people against your government, a particular word or a particular action cannot be considered to be seditious, is what is held in the case of Queen Empress versus Jogendra Chandra Bose, the very first case of sedition in India. I don't know how much this case is relevant right now, but the government has been misusing the even though any person who even makes a drawing about the government, if that particular person is expressing his views against the government, he could be punished under sedition. These are few loopholes under the law that I would say, and I would really want, and according to my opinion, I want this law to be scrapped off. So with this I end my video. Any opinion? What I want the viewers' opinion with regards to this matter and the applicability of section 124 in the current scenario too. So kindly drop in your opinion in the comment section, and thank you so much. Have a great day.